Good morning. I'm really happy to be here with you and even more happy that our tech appears to be working. Thank you to Sergey and Jerry. So before I forget, in terms of housekeeping, if you want to chat amongst yourselves, there's the regular chat function. If you want to send a question to me in the panel, you should use the chat presenter button. The theme for today's presentation is startups in the innovation economy, and we have put together a really fantastic group of experts for this morning's panel, and I'm going to introduce them in just 1 minute. Before that, I should introduce myself. My name is MacInnis, and I'm reporting live from Toronto this morning. I am a lawyer by trade, and besides chairing CanBIM's project delivery and risk management think tank, I am Associate General Counsel at IBI Group, which is a technology-driven design firm. And I manage what is euphemistically referred to as our disputes portfolio worldwide. But as IBI Group has pivoted towards a more tech-driven company, I have had to learn a little bit more about tech startups. So I'm going to be taking notes here with you today. And now to our esteemed panel who will join us, I think, on camera. First is Christy Bates. Christy is an intellectual property lawyer in the business group at Cassels, Blok, and Blackwell here in Toronto. And the sole IP lawyer in our think tank. So thank you to Christy for joining us this morning. Christy's practice focuses on copyright and trademarks. She is a frequent speaker and writer on the interplay between copyright law and architectural works. And I had the opportunity to work on a panel with Christy pre-COVID, so I'm really glad she can join us. Roddy Handa of Holo in Edmonton is a rare combination of architect, lawyer, and problem solver, and is our resident entrepreneur on the think tank. Roddy is currently solving problems at Holo, the company that he helped to form, and also does a lot of great work in the IPD space. He's promised to dish this morning on how he became a successful entrepreneur. Thank you also, Roddy, for getting up really early to be with us this morning. And I think, Roddy, I don't see your face yet, but hopefully you'll be able to join us on camera. Mike is a partner at Dentons here in Toronto, and when last I checked, Dentons is the world's largest firm, which means that they must have a really good art collection. So Mike leads Dentons' venture technology practice in Toronto and has transactional experience on mergers and acquisitions. He has worked on both sides of transactions, so he'll be able to give us a perspective of what investors are looking for and what his best tech startup clients are doing. Okay. So, Roddy, we're going to start with you. All great tech startups come from solving a problem or a need. Can you tell us a little bit more about your road to becoming a problem solver at Holo and what problems you all set out to solve?
Sure. The first problem I tried to solve this morning was making sure my camera works. Can you see me now? Perfect. Yeah, the whole idea behind Holo, we saw a number of problems that we wanted to solve. Some were professional and some were personal. On the professional side, we just felt like the whole industry was fragmented and broken. And it was a very tough problem to solve if you're in a large company, can't really be nimble or venture further outside what's traditionally your scope. So if we wanted to be able to serve other partners on a project or look at unconventional ways of delivering projects, either through different procurement models or by breaking down conventional barriers between traditional scope, we needed to almost be steering that boat. It was a really hard case to make to our supervisors, our vice presidents, our presidents and CEOs to do something out of the ordinary, especially when you have that shareholder oversight that you need to account for. So we really wanted to be able to maybe do things that are seen as unconventional or outside the realm of what traditional architects should be doing. And the only way we could do that is if we wrote the rules. On the personal side of things, I decided to start Holo when my wife was 5 months pregnant, which was probably the worst time to do it. But I don't think I would have done it if she wasn't pregnant. And the problem I wanted to solve there was I didn't want to be going into the office at 7 every morning, home at 5:30, and missing out the bulk of the day with my kids and my family. So with that in mind, I knew I needed a model that would allow me to be around them a lot more, allow me to take my daughter to school because I didn't have to be in the office from 8 to 5. So we wanted something flexible enough to support our lifestyles, but also our professional ambitions.
That's wonderful. So Christy, anyone who's ever downloaded a movie from the internet thinks they understand how copyright law works. But can you give us some background on why copyright is relevant to design professionals and startups, some who are joining us here today?
Yeah, absolutely. So I think whether you're in the startup space or a designer, your asset is your creative output. So if you're a startup, you exist because you've identified a hole in the marketplace. And as Roddy was saying, you've come up with a creative solution to a problem. On the other side, if you're a designer, your main add value is your creative output. You do something that resonates with your client, and it's the originality of that that's making the client interested in you. And so what copyright does is it protects the fixation of your creative output. So it's important to realize that copyright doesn't exist in ideas or concepts. It's when it takes a particular form. So in the AEC space, we're talking about sketches, renderings, plans, specifications, models, and also ultimately the physical structure. And it's the physical embodiment of those ideas that you have. And the different types of fixations, I'll call them, in the world of copyright are called different types of works. So you can have something like a literary work. Apologies about that, talking about technology. Bixby's listening in on this conversation, wants to get the scoop on copyright. Sorry about that. So we've got literary works. So an example of that, it's, let's say, a computer program, so the source code there. Artistic works include architectural works and the drawings and plans. You also have things like compilations, such as databases, and then of course the more other areas such as musical works. And what copyright does is it gives you a bundle of rights in those particular works. So you have, as the author of those works, you have the unique ability to reproduce the work in, or a substantial part of the work in any material form. So going back to the AEC space, if you've got a drawing, because, and you are the owner of the copyright in that drawing, you have the unique right to actually turn that drawing into a building, because that is a reproduction of the work in another material form. So just turning back to, again, so that's sort of copyright in a nutshell. Why should you care? Well, at the end of the day, copyright is everywhere in your field of work, whether you're in the two spaces. And also it allows you to really get the maximum economic benefit from your work. Copyright is an asset. You can sell it, you can license it, and it adds to the valuation of your company. And so whether or not you want to do something or not is a second question, but you certainly should be aware of the fact that it is an asset that you can monetize. And then the second thing to consider is that if a client is going to be paying for you to come up with something, they're not going to be too pleased if their competitor down the street goes and builds an identical building. You have gone to the trouble and effort of coming up with an original project to pay for someone to come up with something that suits your needs. And if someone can go and just copy it completely, you're going to have unhappy clients. So there's the double side of the benefits of copyright to those who work in both the startup space and as well as designers.
Thank you. So, Mike, in my experience, people put off hiring legal counsel. So when do you think people should call you to get the maximum benefit?
It's great to get the problems with lawyers question. Thank you for that. For starting a startup, you actually have in every single company the things that Roddy described. There's a problem. We want to address a problem. I have a vision for how to go about doing it. And also the bundle of problems that Christy mentioned, copyright being one, but more broadly, intellectual property. We get called to put that together and find a vehicle in which it can sit. And we'll start with company formation right at the very beginning, getting companies up and running and ready to go to put the vision, the technology or other intellectual property that's being developed into a vehicle that can grow, be financed, and ultimately sell. Startups all have the same problems. They all go through the same life cycle issues of being under-resourced, having more challenges than they can deal with all at once, ultimately needing to find service providers by way of early employees and contractors and bringing them on to the team. And so one of the things that we do a lot of is helping through our startup program bring companies through that same sequence of decision making to be able to get their company up and running. And it's up and running for either venture capital investing, or it's up and running for the purpose of being run on a bootstrap basis to grow organically. But the phases at which we get engaged are at formation or at the stage that venture capital is being brought on, because not all investment transactions are created equal, and venture capital tries to do a lot of nuanced and complex things in a very tight cost envelope. And we also get brought on when those companies are looking to sell or someone else is looking to buy them, or for us, because as you mentioned, we're a global firm, as companies look to cross borders. And that's a great challenge and ambition for Canadian companies. We're, after all, a relatively small market. The best companies here are looking to grow and scale around the world, and that's what we're set up to do.
Great, thank you. So the key to success, I think, often for many companies, including startups, is having a diverse set of perspectives and advisors at the table. And we have that here today. I'm going to start with Roddy again. What was the best advice that you got when you were starting off as an entrepreneur?
That's a difficult question, mostly because I didn't tell too many people I was going to start a company, and I just took advice without them, I think, knowing they were giving me advice on how to start a company. When I was at my last job, a large architecture and engineering firm, I was sitting actually with corporate counsel because I was articling in that department at the time. And we were talking about what makes future architecture and engineering companies, what's going to make them successful. And we talked at length about this, probably over the course of a few months. Probably shouldn't say that too loud because we should have been working, but we were just jostling back and forth on what would make an architecture and engineering company successful moving forward. And we always came back to this idea that you need to be nimble, you need to be adaptable, and you need to have a good understanding of the challenges and perceived barriers that prevent us from doing those things. So from a nimble standpoint, especially when you're a tech-focused architecture firm, you need to be able to quickly adopt new technologies or at least respond to new market pressures. Because if you don't, you're often going to miss that boat. Or if you're too slow to act on it, somebody's going to get there before you. And I think that was one of the biggest problems we had at my last place of employment, is it had to go up the chain so quick, or had to go up the chain, which took time, and often you wouldn't get the answers you needed in time, and then an opportunity would pass. So that was probably the best advice I took to heart, was this company that I wanted to start needed to be nimble, needed to be able to pivot on a dime, and needed to be able to undertake opportunities when they came up, instead of jostling with whether or not we were actually going to pursue that opportunity.
Well, I was going to ask you what the worst advice was, but since you weren't really taking advice formally, what would you say is something people should avoid?
There was a lot of advice I was given that I avoided. One was, if it doesn't work out, once I announced I was leaving, if it doesn't work out for you, there's always a place back here, was probably the worst advice, because that's the thing I wanted least. Maybe it was the best advice because it motivated me to be successful in starting this company, or at least try to be successful. Other advice I got really early in my career was, you shouldn't be an architect that focuses on technology. There's no future there. I think we obviously see there's a huge future in technology and architecture and engineering and design and construction. But I would have to say that the worst advice I received was, you shouldn't leave a large company because there's so much job security, and there's so much, I guess, security in the broadest sense of the term, which I think we all realize now during a pandemic. There's no such thing as security anymore. Things can change very quickly. What you thought was a secure job and you were never going to leave can very quickly dissipate, and then you're in a position where you either have to start a side hustle or find a quick bit of work to start your own company. And I think a lot of people scrambled into where we find ourselves today. So I think you just have to do a bit of soul searching to figure out what works for you, because there is no more guarantees in today's world, and that's something that I was told there were guarantees, and there certainly aren't.
Fair enough. And what would you tell the beginner entrepreneur version of yourself?
I think I would say don't try to wait until you have everything figured out, because you're never going to have everything figured out. It's never going to be the perfect time to do anything. You almost have to get 60 or 70% of the way there and be okay with trying to figure out the last 20 to 30% once you dive into the deep end. I think I delayed starting Holo Blok probably 6 months to a year because it wasn't the perfect time. And then oddly enough, I took the worst time to actually start it when my wife was pregnant, and I didn't know if we were going to be able to pay for anything. But I think had I known then what I know now, I would have probably pulled the ripcord a lot sooner, got into developing, this company a lot faster. And who knows where we would have been with another 6 months or 1 year of a runway before this pandemic hit. I think we might have had a bit more of a market share, and things might even be better than they have been for us to date. I still have no regrets, but sometimes I wish I liberated myself 6 months to a year sooner than I did.
That sounds like good advice. So Mike, I'm going to give you a chance to brag about your clients just a little bit. What are your best startup clients doing that you think separates them from their competitors?
I think that a lot of it actually comes back to the keys that Roddy mentioned. One is having a vision. Startup companies, great startup companies, imagine themselves as a squirrel dashing across the street, and as you know, there's a ton of traffic. Lawyers are like the squirrels who sit on the sidelines thinking about whether to cross the street, and entrepreneurs are the squirrels that find a way to get across no matter what, knowing that you may have to pivot along the way. What I think we're seeing during the pandemic is companies assessing their vision and whether their vision is actually right, and aggressively using data to pivot. So countless companies, and high-profile ones, have taken their workforce and put them completely remote, like Shopify and like some of our other much earlier stage companies that are taking workforces that are 100 people that have been built on culture and connection, and trying to reproduce that same close environment with commitment to culture and values and strategic vision in a remote environment, and then testing the data as that goes to see whether those decisions are successful. So I think that data test on whether the vision is working and whether different pivots is one feature that you see in successful startups. Another one is, so let's just take that example, taking a culture and moving it remotely, the ability to lead and communicate and generate buy-in. Every good startup starts with a vision and needs to be able to communicate that to their investors, to their staff, to their customers about the value proposition that they're going to deliver. And great companies are doing that, and great companies are financing during the pandemic. And then the last one is a company doesn't need to be the first squirrel trying to cross the street. It just has to be the one that does it best. One thing that you'll hear from startups is, I'm the only one in the space who's doing whatever it is they're doing. And that is almost never true. Usually means that the company hasn't looked hard enough to find out what other people are doing. And that's probably a marker of lack of success, but there always are other companies doing it. How are you going to do it best? How are you going to execute better? What learnings can you take from other companies anywhere around the world that have done some of the same things that you're doing, and incorporate them into your business and do it better? And that's what all of our great startup companies are doing. And the great ones keep doing it as they scale with the same kind of creativity and imagination as they did as early stage companies, even when they've long since passed the early stage startup stage.
Okay. So two words I've heard like many times already, and I think are part of sort of the pandemic lexicon, are pivot and nimble. So those are I feel like it should be a drinking game, but it's a bit too early. So moving on, I guess I'm giving you another question about sort of legal and professional fees. They're expensive. So are there any areas, and as you mentioned, budgets are tight with startups. Are there any areas where you think people can save on money? And it doesn't have to be on legal fees, but it would be good if it was.
Well, take the legal fees first. I think that the general principle is if you're going to go and launch, like Roddy said, when you might be 70% done, or you have to start thinking about launching much earlier than you're probably very comfortable, and for an audience of lawyers, even more comfortable than that, then making sure that you're spending on the things that matter. And that same matrix of important, urgent, important, non-urgent, urgent, non-important, and none of the others. The pressure to be really clear on which quadrant you're hitting as you undertake any step is key. When it comes to legal, companies should be building to either bootstrap and add people successfully or finance successfully, because those are the two paths. And by doing that, one way to save time and money is to try to build along the lines that allow you to do both, and keeping it simple, except in the areas where complexity is needed. So some of the things that can be done simply is getting your company up and running, adding employees, and so on, and anticipating that some of the people that you'll bring on will leave, and you need to have a mechanism to move those people out efficiently and predictably, and ideally with less acrimony and litigation than might otherwise come up. So solving those problems before they come, and setting more important than the legal part is actually setting the expectation. People generally don't fight things that they understood and agreed to in the way that they fight things that they didn't understand and feel they didn't agree to. So generating buy-in, and that's the leadership function that goes alongside legal. And then the second part would be from a financing perspective. One of the challenges as a lawyer, if somebody asks you, is there a way to do this? Unless it's illegal, there usually is a way to do it. It just doesn't mean that you should do it. You should do things that will be predictable and easy to understand for the market, so that when they ask about the financing they can understand, oh, you raised money at this valuation, or on the next round it converts at this discount. And broad deviations from that structure that all investors know will cause at least some of them to say, too confusing, I'm walking away. And part of what you're doing is trying to avoid the too confusing, I'm walking away answer. And then at later stages, when your financings become more complicated, the terms are actually very complex, because you're managing hierarchies of shareholder rights, financial and governance approvals, board rights. All of those things come in a relatively complicated package for investment. And they can't be bespoke every single time. If you're raising money in hundreds of thousands or low millions, it's just not efficient to treat each one of these as if it's the first deal that anybody has ever done. And the industry has developed standard form documents, and there's a bit of a war on for which are the right standard form documents, but starting from a place of broader acceptance is an easier way to generate buy-in and get deals done. And that's definitely what we do, and that's what we see the other firms that we see across the table, the virtual table, but across the table, starting from at the same time. And it's a way to level set expectations and get on the same page, even as you might negotiate things where there's not alignment of interest.
And what kind of standard form documents, just to flesh that out a little bit, are you talking about? I'm
sorry, could you say that again?
What types of standard form documents? I just wanted to follow up. You said there was sort of a race.
Sure. And there's different forms for different stages. For safe financings, which are startup-specific agreements to get future equity that are intended to not be debt or equity. Y Combinator developed a form of safe that is broadly accepted in the US. There are other variants in the US and Canada, but Y Combinator's form is the one that people are usually referring to when they talk about a safe. Or for preferred financings, like you'll usually see in the venture capital world. The Canadian Venture Capital Association has forms of documents that match the same forms that are used in the US as Canadianized versions, and those are broadly used. There are also other forms that different venture capital firms will use that are their own versions of either the same content or the same form. And there's a handful of others that Series Seed has, or the National Angel Capital Association has, or Mars has. And any of those are at worst level sets on what people can expect when they negotiate a transaction, that if we don't ground it in some level set, then we could literally be out here imagining what it would be like to do a venture capital transaction. And there's no way to do that from first principles efficiently.
Oh, that's great advice. Thank you. Christy, when entrepreneurs are first starting out, I think they're often really happy to have their first client and want to make a good first impression. And as a result, I think people are scared to negotiate certain aspects of contracts, including copyright protection, is what I think gets ignored a lot. And I've noticed in my own practice. So starting from the beginning, how will I know if I have or own a copyright?
So copyright springs into existence as soon as you pick up your pen and draw, do sketches, or pick up your stylus and draw sketches, or any time. You don't need to wave a magic wand or pay money. Copyright just automatically exists as soon as you create your work, and it has to be the exercise of sort of your skill and judgment. And I think one of the key things that people don't understand in the copyright space is that there's a distinction between the author of the work and the owner of the work. So the author is the one who's actually picked up the pen, whereas the owner can be the author, but the owner is the one who actually can use it as an asset and sell it, license it, etc. Now, the default position at Canadian law is that if you are the author of the work, you automatically own the work. However, in the employment context, it's different, and especially in contrast to the independent contractor, a situation where you hire an independent contractor. So I'll run through both scenarios. So in Canada, when you have an employee and they make a work during the regular course of their employment, the default statutory position is that the employee does not own the copyright. It's the employer who owns the copyright. So the employee is still the author, but it's the employer who is the owner. Now, contrast that with the independent contractor situation. If you're an independent contractor, that means that if you are creating the work, you are both the author and the owner of the work, which means that even if you hire someone to, let's say, develop in an independent, like a one-of independent contractor situation, where you get someone to develop, let's say, a plan, it's actually the independent contractor who is maintaining copyright over their plans and drawings. And this leads to another important distinction in the AEC space. You, as, let's say, the person who's hiring the independent contractor, you own the physical plans, but there is also so they're the physical plans, or let's say if it's a computer program like a Cad file, there's that, but then there's the copyright in that, and they are separate things. So there's no doubt that you actually own the plans and the drawings. What's at issue in an independent contractor situation is who owns the copyright in that, and the default is that it is the independent contractor. Now, the case law has developed in this space to copyright. It's a tough area of law, and there can be industry-specific trends. And so the courts have acknowledged that in the AEC space, that the client certainly owns the physical drawings once the payment has actually been made for their work, but that the author, so the independent contractor, owns the copyright in the plans and in the design actually embodied in the ultimate structure. And therefore, if you hire someone in an independent contractor situation and you can only actually use those plans and drawings for the intended structure, for the intended project, if you are going to be using it in other contexts, unless you explicitly have a grant of license in your agreement with that individual, you cannot do so without the owner of the copyright's consent. So that's a really important thing to be aware of. There's also other aspects that have been developed in the jurisprudence, such as the right to modify a building. So let's say if you hire an independent contractor to come up with a plan, there's an element of copyright that deals with moral rights, which is a complex issue in and of itself, but essentially it gives the author the unique right to modify the work. And ultimately, you can't modify work if it's to the detriment of the author's reputation. So long story short, if you want to set yourself up well, you want to make sure that your agreement really explicitly lays out what you can and cannot do. Don't leave it to having to call me up or another IP lawyer to have to discuss the case law, because it's not always consistent and it can be a little bit ambiguous. So just be clear in terms of the grant of rights that you want to be getting as an employer or as a person who's hiring an independent contractor. And I know we're going to be discussing this in a little bit more detail later on in the session today.
Yes. And what do you think are the best ways, like from a client and owner perspective, what are the best ways for the owner of the copyright or the entrepreneur to protect their copyright or IP on a startup budget?
So I'd say the first thing to do is to jump on a call with your IP lawyer and discuss your business. I think that it's IP lawyers were trained to automatically be able to assess what is protectable by IP and what is not. But we just need to have a sense of just what are you doing, on the back end, on the front end. So that way we can just come up with a really quick list of, okay, here are the priorities. Here are the things that are easy to protect. Here are the things that are more expensive to protect, because there's definitely a hierarchy in terms of the strength of certain rights, what you can get from it in terms of valuation, also in terms of how much it's going to cost to protect it. So copyright, for example, to register copyright, it costs $50. You can do it yourself. You just need to go on to the government website, put the title of the work that you've created, the date of publication, the name of the author and the owner. It's something very straightforward. Now, the protection it gives you, it's helpful, but it's not, let's say, as an effective method of protection as, let's say, getting your trademark registered. So your IP lawyer, once they understand your business, what you're trying to do with it, where you're hoping to go, do you want to sell it off or not, we can help you structure what is the best way to set yourself up for success. The second thing I'd recommend, and I see this all the time, is that a lot of startups, they try and draft their own agreements. And I completely applaud you for that effort. But oftentimes it'll take your IP lawyer a lot more time to try and redraft what you have attempted to draft yourself. We have stock language. If your IP lawyer doesn't have a whole bunch of different clauses easily on hand that they can try and customize to your business, something's wrong, because you should be able to get some basic IP provisions in your agreements pretty easily. So going back to what I was referring to before, in an independent contractor situation, if you're on for the person hiring the independent contractor, you're going to want to ideally a straight up assignment. And that's very standard language that we should be able to draft. And again, it's much easier for us to put it in as opposed to having to rework something that you've already drafted. And another key thing is to be very cautious of US law. Especially when it comes to copyright, US principles are not transferable to Canada in a lot of different ways. So I'll always know that I'm looking at someone who, looking at a document from someone who's been inspired from a US agreement when they're talking about work for hire. That is not a Canadian concept. It is not transferable, and you really should not be using it. So I think just having that initial conversation right off the bat, and then just letting your IP lawyer help guide you in terms of what can be protected, and then also just do the work for you. That's what we're there for. And it's a lot faster if we can take the lead a little bit with some of those aspects. And then another thing I'd note, it's be clear about your budget. We don't always have to do a Rolls-Royce agreement for you. There is fairly basic language that we can put in that will provide sufficient protection. Another piece of advice that I'd say is really important right off the bat is to paper your chain of title. So to the extent that you do have these agreements where you get that, let's say employment agreements or independent contractor agreements that speak to intellectual property, keep copies of them, because I'm frequently acting for buyers in transactions, and we're going to want to see those agreements, and we're going to want to see that the employer, the independent contractor, has actually assigned or sufficiently broadly licensed their rights for the business to operate. So it's don't rely on oral agreements necessarily, or just a common understanding. That isn't something that lawyers really like to see. And to the extent that you're buying anything, also ensuring that you do have due diligence and do your due diligence to ensure you have that paper trail. And there are lots of other things, but I'll leave it at that for now.
Yeah, no, I think two key takeaways from what you've said is that the prevention is better than the cure. So getting it a little bit of advice early is better, and keeping all your documents. No matter what area of law you're in, you want your clients to have their documents. It's the most important and actually the cheapest thing people can do to keep everything on the straight and narrow. We're going to move on to sort of a virtual checklist, and we have a good team assembled for that. So in preparing for this presentation, I did some Googling because I didn't want to be totally out of my depth. So a couple of things that came up and said you absolutely need to have, and have already been sort of referred to here today, is that you need to figure out your legal vehicle, whether or not you're going to be a company, a sole proprietorship. You need to have a business plan. You need to have your business collateral, like your logos and business cards and all that stuff, and finance documents. But we're here to talk a little bit more with this panel about what I couldn't Google. So, Christy, you've already talked about copyrights. What about that C in the circle? Do we need it? Do you have to put it on everything? Is it worth it?
So the C in the circle just creates a notification to the public that the work is copyright protected. It's certainly not necessary, but it can be a good idea. I think in some cases it will make it easier for you to assert a claim, and for an offense, well, when you're claiming something that's called secondary infringement in copyright, it also will prevent the defendant, so the person who's saying that they didn't infringe, from saying, oh, sorry, I didn't know it was copyright protected. So certainly not necessary, but a good practice. I will say also that it's important. There's an important distinction, again, between Canadian and US law. In the United States, registering your copyright is much more important. It actually opens the door to enforce your copyright in the federal court. Whereas in Canada, copyright registration, it does create a presumption of ownership, but it also gives you access to statutory damages, so it's not as much work to prove the damage that was incurred to you by virtue of the copyright infringement, but it's not as necessary. That being said, it's not very expensive, and it's very straightforward. So to the extent that you think that there could be litigation down the road, it's always good to register copyright very early on, just so that way, if you ever need to send a cease and desist letter, for example, if you've already got your copyright registration, the other side's automatically probably going to rethink what they're doing a little bit more seriously than they would otherwise.
And that's the $50 registration.
Yes, exactly.
That sounds like a good deal.
Yeah, right?
So, and what are your best clients doing, other than the things you've already sort of told us about, to proactively protect their intellectual property rights across the board?
So I would say, again, they're jumping on that phone call early on and taking proactive steps to just ensure that their basic documents are aligned and that they get good IP practices right off the bat. It's very simple to add the language in before you then hire 100 people and then have to get people to retroactively go back and agree to things. If you right off the bat present people with the agreements and with the sorts of rights that you want to be able to claim and the assets that you want to be able to assure that you can back up and say, yes, we do own them, it's best to do that early on. There's obviously a lot of standard form contracts in this space, but that doesn't necessarily mean that you should automatically accept them. Always critically assess the boilerplate in these. Another thing that I'd strongly recommend, a tip for the the startups and for the designers, don't assign your rights. You should license them. That's key. In a lot of cases, your client will not need a straight up assignment. Now, none of my, I do a lot of work for those who are on the client side, so they shouldn't hear me saying this, but in a lot of cases, the client should be able to get everything they need through a broad license. And there are a couple of things on licensing that I think are worth just noting at a high level. A lot of times you'll see in these agreements a right to use the drawings. That is not sufficient. So for example, going back to what I discussed earlier, there's the drawing, but then there's the copyright in the drawing. So you want to make sure that you have a right to use the drawing, but also the copyright in the drawing, that there needs to be an explicit reference to that. And in fact, I don't want to use the drawing because, again, copyright is a bundle of rights. So is it the right to reproduce? Is it the right to actually turn it, go from a model to a physical structure? There should be various, you really should try and specify, if you can, what you want this person to be able to do with your rights. Another key thing that I've seen a lot that I'd caution startups and designers against is the grant of a sole and exclusive license. Mm-hmm. That in the world of copyright does not make sense. Exclusive and sole are different terms. Exclusive means that only the licensee actually can use that right. So if you have the licensor, the one who's granting the right, the licensee is the one who's receiving the right. The licensee is the only one who can exercise that right. Contrast that with a sole license. That means both the licensor and the licensee can use the right, both of them. So obviously that's a pretty big difference. So you always want to make sure that you're clear with your language with that. And obviously you can also have non-exclusive licenses, which means that essentially the licensor can grant the license to the licensee and to anybody else. You also want to specify, do you want to sub-license your rights? Should the licensee be able to give the rights to, let's say, their contractors? Probably. Again, be explicit about it. Don't let it be implied. What's the term? Do you want there to be a cutoff period? Is there a territory? Do you want it to be limited to Canada? Do you want it to be limited to a particular field of use? These are all things that you should be explicit about, because if you're not, I'm also a litigator, and all we do is fight about the things that are not written and that are, the common understandings between the parties that clearly aren't common. Because it ultimately ends up in a dispute. So the trick is to be explicit about as many terms and fields as possible. And the last thing I'll say is oftentimes you won't a lot of agreements don't really specify what the copyright is. I always recommend putting in a schedule what the copyright is. So is it the drawings? Is it the renderings? Is it the CAD files? Even if you can't get into the explicit list of all the individual things, create the description that you want it to be. And you can always go back and amend it. But I think it's important just not to leave it very ambiguous, because that's where the litigation does arise.
Yeah, and typically are those sort of licensee sections, are those in the main contract or is it a separate contract?
So it can be in either. I often like appending it to the main contract, because then if litigation arises, you can always submit it to court without necessarily having to provide the full agreement, which might have confidential or sensitive information in it. So it's just sometimes simpler to have a separate agreement, like license agreement, that's actually appended to the agreement. But either way can work.
Okay, thank you. We'll give you a little bit of a break. I'm going to move on back to Roddy. So Roddy, when you were starting off, how did you structure Holo Blok, and why was that structure the best for you guys?
We knew that we were coming from places where it was a large corporation, and we saw a lot of dead weight, to be blunt, in those companies. We saw people abusing the system, going for 2-hour coffees, perhaps not working as hard as they needed to actually execute the work. So we actually subscribe to, as Christy's been talking about, the idea of independent contractors. So everybody at Holo Blok is actually an independent contractor. Don't worry, Christy, everybody's assigned their copyright to Holo Blok. I made sure of that. But what we wanted to do is build a meritocracy, and it's oddly almost a socialist version of capitalism. So we're all required to bring in work. We're all required to share work. But the biggest distinction is if you're not working, you're not getting paid. And obviously, if you are working and generating greater value, then we're able to compensate people more than perhaps they were at their day jobs when they were raking in $30 or $40 an hour. So for us, having an independent contractor scheme was important, but we still wanted to give everybody ownership in the company and a drive to see the company succeed. So most of our independent contractors are actually also shareholders of the company. They're able to, it allows us to be a little nuanced in how we compensate ourselves. We can both invoice, we can take out dividends, and depending on everybody's situations, we have different classes of shares, so we can be a bit more flexible in how we extract money, and we can be a bit more personal. Obviously, that scheme's not going to work forever as we grow. Having 250 classes of shares would be a nightmare, and I don't think I want to see the legal bill for all the resolutions that we'd have to do for that. But, sorry?
I said I was just going to interrupt you to say that'll be good for your lawyers.
Yeah, it will be. Well, hopefully, I can still take care of most of it myself in-house, but I don't know if I want to at that point.
Yeah.
But yeah, it was really important for us to start to build an architecture firm where everybody felt a sense of ownership, because we saw a lot of people disenfranchised in our day jobs, and it was for a multitude of reasons. And once we looked at a bunch of ways to structure the company, this seemed to make the most sense. It gave us the most flexibility, and it allowed us to take out some of the administrative burdens of having employees, including source deductions and all the employment contracts and the complexities that come along with that, a true employment relationship.
And so are the independent contractors just individuals, or did everyone set up their own corporation and invoice you through that?
It's a bit of a mixed bag. I would say most of us are just sole proprietors, so we do have arrangements in place to limit liability, except if they're doing something they really shouldn't be doing, because we still want people to feel safe when they're working with us. We still want a lot of the benefits of an employment relationship, but we also want, we loved a lot of the hallmarks of an independent contractor relationship. So everybody's responsible for their own software, everyone's responsible for their own hardware, their hours of work. All we ask is when you commit to doing something, you actually do it on time. But we found that through that type of structure, we're not spending a ton of money on 1,000 Revit licenses when only 100 people are actually using them. And it allows all of our team to be specialized in areas. So we have one person who focuses on rendering, and we only have one rendering license for that individual because he's the guy. And everybody else isn't picking up the burden to make sure everybody has the latest version of every piece of software. We're much more lean in the sense that we only purchase what we need. And because of that, there's a lot more money to go around at the end of the day. But I think the biggest thing for us was when we approach a client, we say, you pay us $100,000, you get $100,000 of value. Whereas if you went someplace else, you'd only get $80,000 of value, because right off the top, you're taking 20%, sometimes 25% to an overhead bucket that pays executive compensation and a bunch of printers. And we didn't want that. We wanted to generate more value for our clients.
Okay. And can you tell us a little bit about how the profit structure works for the independent contractors and shareholders?
Sure. It's a bit of a formulaic process that we developed. So every time we invoice, or before we even start work on a project and the project comes in, the team that's going to work on a project, we'll circulate the opportunity with everybody in the team, and anybody that wants to work on it basically raises their hand so we can have a kickoff. And then from there, everybody starts to commit to certain scope of work, and collectively we decide how much is that worth to the project. So one person might be responsible for all the construction documents, and we deem that to be 60%. Another person might be in charge of the concept design, schematic design, and we'll deem that 20%. But we set up those parameters at the beginning of the project, and then we verify that everybody said what they were going to do at the end. I know that there's prompt payment legislation already in Ontario, and it's starting to come here. We just got that announced. But right now we're on a pay when paid model. So our independent contractors typically get paid when that money comes in and crystallizes in our bank account. But the way we're really structured is, I said we had no overhead, but we still have some overhead because we have to pay lawyers mostly. But 10% of all of our revenue goes to our overhead, and we're hoping now that we're in our third year, that balloon is going to grow, and we can use that money on R&D and investment in either projects or other opportunities. 20% goes to the project manager, and in that sense, we mean the person who chases the work, who writes the agreements, who issues invoices and makes sure money's collected. So that's usually me, because I have a big bark, even if I don't have a big bite. But I tend to take on a lot of that, just because that's where my expertise is, and that's what we're trying to foster here, is use the expertise that you have at the table. And if you want to get out of your comfort zone, certainly do that, but be as effective as you can, because that's how you really generate larger profits for yourself. And then the remaining 70% go to the production people or person. And any of those pools of money can be split between individuals. So you could have 2 or 3 people doing project management, or 5 people doing production. It depends on the scale of the project. But once we have all those percentages set out and the invoices are paid, we have a overall spreadsheet that consolidates what we call your Holo Blok bank. And then quarterly, independent contractors can invoice against that bank. And then semi-annually, we have provisions for people to see if there's any money in there that they want to withdraw by way of dividend. And assuming we comply with all the requirements in our Corporations Act, that a dividend is issued to those people so that they can do as they please with that. Obviously, there's advantages if that dividend or that compensation is issued to another corporation. But with our individuals, they like to keep it simple, and it's mostly sole proprietors that are taking those amounts out.
Wow, that's really comprehensive. Thank you for sharing. So, Mike, moving on to you, I imagine you get asked a lot of non-legal questions as part of your practice. What do you get asked most, and how do you answer?
Most of the questions that we get are really around how do we scale? What are the best ways to scale? And scaling means something different at every stage. So at early stages, it can be, how do I scale my relationships to connect to the investor community, whether that's angels or venture capital investors or corporate investors, since we work with all of them. And as you said before, we work on both sides of deals. So connecting people that we work with to other people we work with is a natural and a given. We're also asked sometimes to find advisors or tech talent, or recommend accelerators, and so on. And again, those are things we do. We're also asked on the other side by VCs what we think of the companies that they're looking at, that we know about. So it really is a two-sided vetting of the credibility, integrity, ability to deliver. And at early stages, in addition to market size, it's really about team and the quality of the team. And venture capital and startups are really long-term bets. There's not usually short wins, or if you go in anticipating that you'll win quickly, you're likely to be disappointed because the ride is a long one. And it's very much a marriage between investors and a company, and founders and co-founders and early staff and company leadership. And helping as a source of vetting is one of the things that we do. We try to do this by, as I mentioned before, having a startup program, a way to shepherd companies through the stages of their development, and a plan for documents and approaches that will be accepted by venture capital investors and buyers and so on. And we participate as mentors and advisors in parts of the ecosystem, like the accelerator community, and so on. And all of that is with the effort to service the ecosystem rather than only specific companies. So that's mostly on the startup side. And all comes back to, how do I scale when I don't have resources? On the corporate side, it's really more of, how do I get comfortable doing something that we don't normally do? Like we run a multinational architecture firm. That's what we do, and that's our business. How much time should we be spending? How should we engage with a company that wants to do a $700,000 financing? That's a pain point for large corporates, and it's again something that we help with both on the legal side and also in the way to think about turning a large organization to something that is otherwise relatively small for a large company.
Okay. Now, when we were preparing for this presentation, you told me that not all corporate investors are looking for a financial return. And as a lawyer who works for a company that is also an investor, I was a bit offended, but I promised to let you speak on it anyway. So here we are. What are the opportunities and challenges where corporate investors are investors as well as customers and distribution partners?
So it runs the gamut, and I'm sorry for offending you, because that just shows where your company is on the spectrum. So there's no company that doesn't like making money. They all like making money, but some companies won't invest unless there's also a collaboration on the customer side, and it's really that drives any investment. And without it, they just won't invest. Period. Full stop. And that's the continuum. A company that acts like a VC investor and one that acts just like a customer. So on the customer side, it's really about taking that $700,000 investment that I mentioned and plugging it in to a $100 million, billion, $20 billion business and generating larger returns off the core business of the company, and making sure that in the process they're not exposed, i.e. not exposed to information that they don't want to have that would restrict them from taking advantage of other opportunities, not shackled in terms of businesses that they may want to take on, but at the same time having enough influence and insight into the company's business to be able to participate in decisions that are important to the investor. And all of that comes with a nuanced conflicts regime around how to get comfortable partnering together between the elephant and the mouse.
Okay, so we're running out of time. I had a lot more questions for you, but they all sort of boiled down to this, and I'm going to give you each 30 seconds in the lightning round to answer. What do each of you, I'll start with Christy, what do each of you believe are the sort of trends in your practice at the moment, and where do you think it's going in terms of the future? 30 seconds. Christy?
Yes, pressure's on. So I think the one thing I'll flag is the 2017 Lane Co. decision. We saw a decision come out of the Quebec federal court that essentially has awarded $700,000 worth of damages for copyright infringement in a situation that would not traditionally, I think lawyers would not advise there would have been that significant award of damages or even a finding of copyright infringement. And the one, it was for a soccer stadium. And I think the court acknowledged that basically it was putting together fairly well-known structural elements, but what was protectable was how it was assembled. And there was a traditional opinion that utilitarian features aren't subject to copyright protection. But what the court noted was that buildings always are going to have some form of structural and therefore utilitarian aspect to it. And that is not a bar to having copyright protection. So essentially, the conclusion is you should, even though copyright hasn't necessarily been at the forefront of your mind for your AEC business, it should be, because the door has now been opened to award significant damages. So at least whether your company has a philosophy of protecting copyright or not, at least on the defensive side, make sure that you are engaging in practices so that way you don't get a nasty cease and desist in the mail. And that can be relatively easily done once you speak with a lawyer and sort of understand the ins and outs of copyright. So that's it.
Okay, thank you. So I'm advised we have a little bit more time because there's a break after this. So you guys can each have a little bit more time. Roddy, I'll go with you next. What's on the horizon for Holo Blok and sort of the industry from a larger perspective?
Sure. We're a bit of an unconventional firm, and I'm really glad that Christie's here, because we think IP is kind of the next big thing that needs to be tackled in this industry, especially with a growing trend towards building information modeling, multiple authors to these documents, not very a clear-cut line who contributed to what. You're always reproducing the work of other people. Unless you have that license in place, you're technically infringing their copyright when you use structural engineers model for your underlays, and you're reproducing it by every sense of the word. So we're unconventional because we're an architecture firm, but we're also a building solutions firm. And by that, we mean we're implementing technology with any stakeholder across the process. And I think that's where we still want to keep going. We want to bridge the gap between design and construction, We want to be supporting trades and general contractors that want to implement technology. We want to, redefine the barriers of what architectural obligations are when you're developing construction documents and you're consulting for an owner. I think there's a lot of positive movement towards more progressive procurement models that are going to enable us to do that. It's going to set aside a lot of these issues related to ownership and copyright, I think, just because in an IPD setting, there's a waiver of liability and a waiver of being able to sue your partners. And there's often these considerations are all brought to the forefront of the agreement, and whether it's a CCDC 30 or some other agreement, people are starting to think about architecture and construction in a very different way. It has to be collaborative. You don't have this architect sitting in his silo drawing everything that's going to be reproduced. It really is now largely a contribution from various sources. You're using basis of design from manufacturers and suppliers. You're using knowledge from trades. You're using knowledge from general contractors. And I think that this industry needs to recognize that. And I think you'll see the role of consultants being redefined so that we can actually finally see some progression in this industry. I've been in it for 10 years now, and I haven't seen anything change, and I'm getting a little stale about that.
Yes, impatient, which is good for an innovator. Okay, Mike, we'll close off with you. What do you think are the trends in 2020 for your practice and going forward?
I had a 30-second answer prepared, but I'll expand a little bit longer. So the first one is when the pandemic hit, the immediate reaction was, oh man, startups are not going to get financed anymore. Startup financing is completely dead. And that's not what happened. Although in some markets in Canada, funding volumes are down both by deals and dollars. That's not true across the board. There have been pockets of great activity. So I'd say that the market is pretty robust, and that's a great learning because it shows that we're producing good companies for the future. At the same time, certainty of getting companies funded is still dropping. So I think that companies are going to be looking to exit earlier and earlier than they had before if they can't find a path to revenue. So the challenge for companies to find ways of turning on the revenue stream earlier has changed a little bit because there can't be the presumption that someone will be around to finance. A third trend is more and more accelerators showing up, and some with specific verticals, some with broad reach. There's even one called Reach. Right, they're really showing up everywhere. And then fourth one is solutions that are coming to market are addressing the issues or taking existing companies and pivoting them to the issues that has us collaborating remotely from homes and offices across Canada. Remote work, office, return to work, office wellness and health and safety in the office, and new tools for purely online businesses in terms of the various things that weren't available before. So the market is really reacting in terms of what we're seeing come forward. But I think that most of the companies that are starting out and have done early financing need to look to exit more quickly.
All right, thank you. We have already 2 questions in the queue. The first one I think would be for Roddy, but anyone's free to jump in. Since we are in the as-built BIM world, is creating a BIM protected under copyright? Sorry, that one's for Christy. Do you think like a building information modeling, the 3D modeling, is that protected under copyright? Sorry.
It probably is better for Christy. I have a lot of passion in this area, but I'll share an article I wrote with Christy after, and she can tell me if I'm wrong.
Sorry, I was just trying to find my mic. Yeah, so I'd say there is certainly copyright in Cad Files, and in terms of how it's the layers, right? So as I was saying in the lane code decision, let's say if you've got just like a basic a beam that you put in, there's not really copyright in that. It's not original. It's how you put the elements together. And as what Roddy was referring to is it gets really complicated in when people are like, changes are constantly being made and it's a collaborative project, because at the end of the day, it's a work of joint authorship at copyright. That's sort of the legal concept for it. And joint authorship, it gets very messy because in order to do a lot of actions, you actually need the consent of the other parties, which is why, again, what Roddy was saying is important, is that at the front end to have these conversations and either decide, like when you look at the software space, for example, there's open source licensing, there's copyleft, principles of copyleft, which essentially says, okay, look, we acknowledge that this is a thing that can be protected, but we are actively deciding that we are not going to sue each other for it. We're going to allow for the collaboration to go forward. And sometimes, let's say in a copyleft situation, there are certain obligations that go along with that. So for instance, it might be that anything you then create also has to be can't be, let's say, monetized, or it also isn't subject to restrictive licenses as well. So it depends on the individual work. It's hard to say in the abstract, is that going to be subject to copyright protection? It just depends what is actually in it. But generally speaking, the bar for copyright is very low. And so long as you have exercised skill and judgment in putting something together, then there is going to be copyright in it.
And is there, this is another question for you, is there, so the person has said, I know that surveyors have copyright in their survey plans, would be the same for like the as-built drawings that BIM creates. So whether or not the output.
Yeah, so there is copyright. So going back to the example I gave at the very beginning, so let's say you have a drawing and then it turns into, let's say, a model. That is a reproduction of the original drawing. So in order to do that, that is an infringement of the copyright. So each way along the chain to the ultimate building, to the structure, there is copyright in each aspect. And you need a license from sort of the original creator, the author, to then engage in the next activity. But if the person at that next activity, let's say at the model stage, makes changes, they own the copyright in the changes. So you see how it can very quickly get quite complicated, which again is why you just want to have conversations up front in terms of who can do what, and what the consequences are of sort of engaging activities outside of that license.
And Roddy, have you had to deal with that in the IPD context, dealing with everybody who owns what, or is it dealt with in the contracting stage?
Typically dealt in the contract. So there's good language also, I think, in the IBC appendix, BIM appendix, that states all participants and all model element authors retain their copyright, but they license the use of their work for the purposes of designing, constructing, and I'm going to get this wrong, so forgive me, designing, constructing, altering, maintaining, operating. There's a set defined criteria that you can use the copyright for, and that it's nice that gets addressed early. I think the IBC does a really good job of actually doing that. So if people are looking for boilerplate stuff, I would look there and then go talk to Christy and she'll tell you how to fix it. But then we do that all the time. We think that we think there's actually no place for copyright in architecture. We say that kind of tongue in cheek because there still is a place. But in terms of making the industry move forward, we think that there should be that license with all the participants, and that license needs to be extended for any future modifications, because we're working on a university building here right now, and technically that copyright exists with somebody. And by going in there and redrawing the existing conditions, we've actually reproduced that in a material form that would constitute copyright infringement. And unless that owner has a license and the ability to sub-license it to his new consultants, everybody's kind of on the hook for this infringement. Nobody really ever enforces it, but I think it's a live issue that people don't really tend to appreciate. So having that language like in an IPD contract or the IBC appendix helps avoid that, helps avoid the big bill that Christie's going to ask for when she has to go litigate it in court. But and everybody's a bit more, I think it was either Christy or Mike that said, when people have these understandings from the beginning, you're not going to fight about it, especially if they're informed and they understand what they agreed to. You don't really have any standing to argue after the fact. And I think that's the best advice that anybody can have when they're getting into any sort of a commercial arrangement, is make sure that those expectations are aligned and they're set and they're clear.
Yeah, no, I think transparency is really important, particularly in the past year. I think we've all learned that in our different practices. There's one more question. I think it's IP related again. So Christy, get your mic ready. What about keeping your IP a trade secret? Are there setbacks and advantages? Does it work, or is it just a bad idea?
Trade secrets and confidential information can somewhat be used interchangeably in Canada. In the US, they actually have trade secret legislation. In Canada, we do not. I think the Kentucky Fried Chicken magic recipe is always the quintessential example of that. So if you can, in fact, keep it a secret, it's great. Like, it's very easy to do. You just need, easy per se. You need non-disclosure agreements, and you need to ensure that you enforce them. The problem is, how can you, if someone can ultimately reverse engineer what you're doing, you're not really going to be able to protect it. So it's only appropriate in circumstances where you really can enforce that protection and where it can't be easily reverse engineered. But generally speaking, it's always a good idea to have confidentiality provisions in your employment and independent contractor agreements, or when you're speaking to prospective clients or even investors. Like, you need to ensure you have an NDA before you tell them what your secret sauce is. Because otherwise you'd be amazed at how something can pop up that sounds awfully familiar. So it's important to take best practices in that space in terms of ensuring that you're protecting what you do.
Thank you. And I guess, I saw that you might want to come in.
Can I jump in? Because it's interesting. I think that all of that advice is right. But then what do you do if your investors say, well, I don't sign NDAs? And there are a lot of venture capital firms that just won't sign NDAs. I think that Christy is bang on. And I think the question is, are you Kentucky Fried Chicken? Can you protect that trade secret? What does your future look like? Everything we've talked about today is about building for scale, and the ability to scale your IP for the company that you're going to become is really the question that your lawyers need to answer for you and with you, and to connect you with someone like Christy at the very beginning, because the 1 hour with Christy at the beginning, or 1 hour with a litigator at the very beginning, saves you tens or hundreds later of solving a problem. You just can't put the genie back in the bottle, and one solution that may work for one company may not work for another company. And in every case, it's always about looking to the future and what you're actually going to have developed that is valuable, that will distinguish you from your competitors in the market. And that will always drive you to the right way to protect your intellectual property.
Okay, thank you. I think that's it. I don't think we have any more questions, unless, I think that's it for us. Well, thank you guys so much for all your time and insight. I've been taking notes the whole time, getting my own little bit of free legal advice, so thank you. And thanks to everyone who joined us today.
Thanks, Catherine.
Thank you.
Thank you.
Thanks. Bye.